This program is brought to you by Emory University.
Thomas Aquinas is also a connection between Gene Porter and our next speaker, Russell Hittinger. Russell Hittinger is a wonderful scholar of Thomas Aquinas. He is the Warren Professor of Catholic Studies at the University of Tulsa, where he's been chairing the philosophy and theology departments. He's taught at Fordham, at Princeton, at the Graduate Theological Union at Berkeley, at Charles University in Prague. He has been an exquisite commentator on the richness of the scholastic tradition, but then also its modern application. The last 3-minute riff that Professor Porter gives us is, in many ways, what Russell Hittinger has been doing in a lot of his work over the last 30 years, trying to organize for people within and beyond the Catholic tradition the richness of the tradition and how it comes to bear on fundamental questions, working out a neo-Thomist natural law theory, natural rights theory for the world today. He has done that in a number of different books. One important book is The First Grace, Rediscovering Natural Law in a Post-Christian Age. Another is a book just out on Thomas Aquinas and the Rule of Law. We've had the privilege of getting to know Russ as a contributor and a leader of our Christian Jurisprudence Project. He has been here with Gene Porter as a McDonald Senior Fellow in Christian Jurisprudence, and we have watched him in the context of that project develop 2 books which are imminent from the press, one on paper wars, the papacy and the modern state, which takes his ideas of rights talk in the papacy from the French Revolution through John Paul II, and opens up the discourse of human rights in and on Catholic terms, and deliberately working with a repristination of the insights of Thomas Aquinas and some of the scholastic tradition. And the second book that we're looking for from him is Aquinas' Questions on Law, a primer, where he's going to move beyond human rights discourse into broader questions of Thomas Aquinas, the jurist, Thomas Aquinas, the lawyer, Thomas Aquinas, who actually can do subtle jurisprudential things. And this wonderful mind has been open to us many times in fora that we've organized in our Law and Religion Center, and it's with great delight that we welcome Russ Hittinger back to open up the wisdom of Vatican II. Professor Hittinger.
To both John and Al, thank you for making all of this possible. Stanley just left, but I should say it was 41 years ago this semester I took my first theology class. Stanley Hauerwas was the teacher. I just had randomly signed up for it. And it was in that class the first time I ever read Dignitatis Humanae. So thanks, Stan. He's on his way to the airport. 50 years ago, last April, in the interlude between the first and second sessions of the Second Vatican Council, Pope John XXIII issued the encyclical Pacem in Terris, which listed some 25 human rights in the language of natural law. Quote, "Also among man's rights is that of being able to worship God in accordance with the right dictates of his own conscience and to profess his religion both in private and in public," unquote. Recently found and released notes of his team of writers for this encyclical show very clearly that 3 sentences on the right of religious liberty received more internal discussion and debate than any other theme of the encyclical during its drafting process. Interestingly, the Pope did not allow his encyclical to be vetted by the Holy Office, precisely because of the sentences on religious liberty. He wanted that encyclical to go straight into publication without any curial interference. Does it remind you of a recent pope? He unilaterally used the papal office to declare solemnly a right ahead of the council's own deliberations. He forced the hand of the bishops. Now, in the spring of 1963, when Pacem in Terris was issued, he died, by the way, only a few weeks later, and on the subject of Dr. Martin Luther King Jr. Exactly 1 week after Pacem in Terris is a letter from Birmingham jail that quotes some of the same authorities that's in Pacem in Terris. Whether Dr. King read Pacem in Terris, I don't know. It was a wonderful coincidence in any case. But in that spring, the subject of religious liberty had been slated by the Vatican Council for inclusion in 3 different documents, all of which were being drafted at the same time, as a subsection of a document on the nature of the church under the category Relations between Church and State. Second, as the subsection of a document on ecumenism, specifically under freedom of cult. And third, as a subsection of the document on the church's relations to non-Christian religions. In effect, what eventually turns out to be the most important issue of the entire Vatican Council was buried deep within other documents. But it was Pope John's encyclical that guaranteed that the subject of religious liberty would become a freestanding document. Ultimately, the Second Vatican Council produced 16 documents, but 2 documents in particular, moved this right of religious liberty from the 50-yard line, which is where it was with Pacem in Terris, all the way into the end zone. First, the Constitution Gaudium et Spes, sometimes called the Church in the Modern World, which is the longest of all of the Council's documents, more than 25,000 words in Latin. Gaudium et Spes is rather loquacious, speaking about everything from the Enlightenment to the 1960s. And in the mid-1960s, it was considered to be the quintessential Vatican II document, that is, announcing no doctrine, but locating the mission of the Church in real historical time. On the other hand, Dignitatis Humanae, the Declaration on Religious Liberty, is the second shortest conciliar document, a mere 4,600 words in Latin, which amounts to about 8 single-space pages in our usual 8.5 by 11 format. Even so, it took 4 years to compose it, and the final draft was signed only 24 hours before the council was adjourned. Why such protracted labor on this Declaration of Religious Liberty, which hardly amounted to the size of a student term paper? Well, during the drafting process, some bishops worried about strictly philosophical questions. What's the precise meaning of conscience, and wanting to draw proper distinctions between subjective and objective conditions for the exercise of conscience. Some bishops worried about entirely practical items. What would be the effect of a declaration of religious liberty on Vatican concordats with various states? Others worried about ideologies. Is this going to let in certain kinds of modern ideologies, indifferentism, laicism, into the council? Still others worried about how to interrelate canonical, international law and natural rights. Most of the bishops that were on the commission drafting this wanted the document to clearly rehearse and settle the broken history of church-state relationships, basically going back to Constantine. Gradually, by trial and error, the commission and the conciliar bishops realized that this declaration could not do all of these things. By the time of the final vote in December 1965, more than 2,000 corrections had been undertaken. By the way, almost every sentence of Dignitatis Humanae had been corrected multiple times. This had the good effect of producing an exceedingly tight and carefully reasoned statement. The downside was that a strong line of historical narrative is absent. It was just left for another time. In fact, the only clear historical marker in Dignitatis is the opening sentence. Quote, "A sense of the dignity of the human person has been impressing itself more and more deeply on the consciousness of contemporary man, and the demand is increasingly made that men should act on their own judgment enjoying and making use of a responsible freedom, not driven by coercion, but motivated by a sense of duty, unquote. For a reader coming to this document today, this is surprising. No document of the Second Vatican Council more speaks the language of development of doctrine and addresses the troubles of Catholicism in modern times than Dignitatis. And yet the position is given without any historical narrative whatsoever. Instead, Dignitatis is arranged in two parts. First, under the heading of religious liberty in general, it treats human dignity according to natural law. With this sentence, this phrase, as it has become more fully known to human reason through centuries of experience. The second part of Dignitatis Humani considers the liberty of the Church in the light of revelation, sub luce revelationis, where dignity pertains specifically to the institution and doctrine of the Church. And here's a problem. The sequence of these two parts reverses the historical order of discovery. Part 2 of the document is actually prior to Part 1 in the order of time, discovery, and the development of doctrine. And this is something more than a merely rhetorical issue. The development of magisterial Catholic thinking about a natural right to religious liberty follows the vector of affirmations made about the Church's liberty going all the way back to Vatican I, 1870. Now, I can't give all of the evidence for this in its proper detail and complexity just here, but I'll give a synopsis. Basically, why, when you teach this document, you should read it backwards. You learn a lot. Okay, here's the summary of what Part 2 of the document says. The freedom of the Church is the fundamental principle, principium fundamentale, in what concerns the relationships between Church and governments and the entire civil order. The Church claims freedom as a spiritual authority established by Christ and rests upon its duty to preach the gospel to all men. The law of the true religion is given to the baptized, who are elected by God and constituted as an ecclesial people called the Church. France or the Austrian Empire may be exceptional peoples in their own time and place by virtue of cuisine or beer or whatever, but they are not elected by God to be made as living stones. I mentioned before there were thousands of corrections and emendations of the drafts as they went along. But if you read the debates of the council over the document, there was relatively little debate over Part 2 concerning the liberty of the Church, because that issue had been more or less settled a century earlier at the First Vatican Council. When Pope Pius IX summoned the First Vatican Council, the temporal sovereigns were not invited. It's the first council of the Church in which temporal sovereigns are not invited to participate in the council. Of course, at Nicaea, not only were the temporal sovereigns invited, they presided. Constantine presided. That's where he called himself the 13th bishop. So in July 1870, in a document called Pastor Aeternus, the Vatican Council decreed freedom from governance by temporal authorities, and it recognized the universal jurisdiction of the Holy See. In principle, that council erased more than a millennium of a kind of quid pro quo arrangement governing church-state relations within political Christendom. In exchange for official recognition and protection, temporal sovereigns were regarded something like junior apostles, entitled to govern many aspects of ecclesial life, including the nomination of bishops and abbots, to veto the proceedings of synods, even candidates at papal conclaves. What's more, they were granted power to enforce ecclesial decrees regarding missions, inquisitions of heretics, and along a still wider front to govern virtually anything that could be counted as church property within their jurisdictions. The church had become, over the centuries, a political Christendom, nothing other than a kind of religious dimension of the state. By the late 19th century, many churchmen had come to believe that this kind of political Christendom was a charade, or even worse, and more accurately, it was a sacrilege. That is, sacrilegious misuse of a holy thing. And the sacrilegious acts in this quid pro quo were not committed only by lay princes or by parliaments, but by churchmen who for centuries had exchanged the liberty of the church's own constitution for temporal advantages. So the effort of Vatican I to separate the constitution of the church with its own rights, responsibilities, and liberties from the constitutions of temporal polity represented a profound realization. Let us say what Stan Hauerwas said in the last session, a profound remembering, and implicitly a profound repentance. The church, with its ordinary sacramental powers, its constitution, its rights and responsibilities, does not exist by virtue of natural law. Contrary to the assumptions of political Christendom, the church is not a part of the ordinary frame of things. It is not the religious expression of laws, customs, and conventions grounded proximately or ultimately in natural law. This is exactly what Part 2 of Dignitatis lays out. It repeats that teaching of 1870. If the church is instituted by Christ and endowed with teaching, ruling, and sanctifying powers, won by the incarnation, death, and resurrection of Christ, the liberty of church cannot be reasoned to by way of a natural law or natural right argument. It exists by virtue of divine law, and it's constituted by the grace of the Holy Spirit. Thus, the constitution of the church requires the assent of faith. And to use Thomistic terminology, the assent of faith, its formal object is God revealing. Indeed, to make the church's liberty, in the first instance, a tailpiece of a natural right would be to misrepresent the ecclesial bond in terms of its origin, its function, and its end. The right and dignity of the sacramental power, the priest at the altar, or spouses consenting in holy matrimony, might include principles of natural right, but the specifically ecclesial nature is by divine institution. So the Catholic Church's reckoning with religious liberty first had to be settled according to this ecclesiological vector. This fundamental principle was simply reasserted and dropped into Part 2 of Dignitatis Humanae. That's why you have to read it backwards if you want to see it in historical time. Interestingly, the relator of the commission drafting this document was Bishop de Smet, who was from Belgium. And I have read his interventions. A relator basically is the moderator of the discussion within the commission and takes its findings to the floor of the Vatican Council and then takes the complaints or suggestions of the bishops back to the commission. So I started reading his relations, and consistently he refers to Part 2 of the document as Part 1. And Part 1 is Part 2, because the way the people who wrote this were thinking, the first principle, which we have already affirmed, which is the liberty of the church based upon divine law and institution, is what we've already discovered or rediscovered in 1870. And Part 2 is the further extension of this under a general right of religious liberty that can be reasoned to and from the perspective of natural law. Basically, pacem in terris. So, the drafters of Dignitatis Humanae were in the face of a kind of dilemma. In the order of principles, you can't read from Part 1 to Part 2. It took me close to 41 years after being in Stan's course to figure out that you can't read from part 1 to part 2, because that could and likely would suggest that church liberty is the sum total of individual rights of conscience. By the way, you can read from part 2 back to part 1. Read backward, the danger would be the general liberty of all human beings based upon natural law could seem to be a mere afterthought rather than a position arrived at and crafted after much thought and on a ground of liberty quite distinct from revelation. So what they did is they split the difference. As I say, I can't give all the evidence for this, but so Lumen Gentium, the Constitution on the Church, and Christus Dominus, which is the document on the authority of bishops, puts part 2 before part 1. So you get it all in the right sequence, and Dignitatis did it in the reverse. But it was done in the reverse, the natural right first, and then what could be called the divine right, on the assumption that the difference in order of the two positions would be understood as distinct. Now, the first part of Dignitatis, which the Council kept on referring to as the second part, part 2 of our ongoing reflections over a century, grounds religious liberty and human dignity. The human person has the capacity and moral obligation to pursue the truth, to adhere to it once it is found, and this moral obligation can be satisfied only by free intellective and volitional acts. Religious acts have the additional dimension of being ordered to God and therefore transcend the order of terrestrial and temporal affairs. Injury is done both to the human person and to the order established by God if the free exercise of religion in society is denied. Catholic liberty, then, rests on two foundations. First, on divine revelation as to the Constitution, ordinary powers, and mission of the Church instituted by Christ. You could call this a truly inalienable right because the Church has no ground upon which to transfer that authority or to reassemble the Church as a civic association or a national polity. That one truly is inalienable. Second, on the moral ground of the duty and right to pursue the truth about God and to enjoy certain immunities from state coercion in what pertains to this duty. It's basically a riff upon St. Thomas, the inclination to know the truth about God. Questing, finding, communicating, those kinds of acts connected with the inclination to know the truth about God. And it assumes that the human person, the bearer of this right, is open to reality as a whole. And it's on virtue of that, it transcends the political common good. Right? It deserves recognition even without the formal assent of faith. Rather, it's a reasonable assent to what our nature puts us up to, and it's inalienable in that sense. I think Epictetus's famous fragment nails the point, although Dignitatis does not quote Epictetus for this purpose. Were I a swan, I should do after the manner of a swan, but now, since I am a reasonable being, I must sing to God. This is my work, and I will do it, and I will never desert this post as long as it's granted to me to hold it, and upon you too, I call to join in the self-same hymn. So the first part of Dignitatis does not pretend to evaluate the myriad ways that the inclination to know the truth about God is spelled out in the religions of the world or in the secrets of the human heart. It's not about institutional inclinations, customs, mores, laws, or second nature. Rather, it's about the human person. In the very last session of the Council, Paul VI had this to say about part 1 of Dignitatis. I'm just going to quote 2 sentences. He had a lot to say. Quote, "To appreciate it properly, it's necessary to remember the time in which it was realized, a time in which everyone admits is oriented to the conquest of the kingdom of the earth rather than that of heaven, a time in which forgetfulness of God has become habitual, A time, moreover, in which the soul of man has plumbed the depths of irrationality and desolation, a time, finally, which is characterized by upheavals and a hitherto unknown decline, even in the great world religions. The theocentric and theological concept of man and the universe, almost in defiance of the charge of anachronism and irrelevance, has now been given a new prominence by the Council. He's referring to part 1 of the document. So, part 1, the natural right or natural law argument, explicitly depends upon a theocentric humanism, to use Paul VI's term. And what it does, it joins together, without confusing, human persons questing, practicing, and communicating by nature, by natural inclination, with the church, who is also searching, faith-seeking understanding, preaching, and sanctifying. So the divine law meets the natural law by a kind of analogy. Right. Questing, finding, communicating. The Christian preacher, then, is at one level exercising a natural right to communicate the truth about the absolute. At another level, he's exercising his munus, or duty, or function, instituted by the command of Christ to preach the gospel. This nice picture, the highest level of what the inclination of man, human inclination, can put you up to, and that which is revealed by Christ and empowered by grace, that linked very much depends upon the theological premise of the natural right. That is, that in human nature is a natural self-transcendence. Knock out that anthropology, and the analogy between parts 1 and part 2 of the document start to collapse. And the right, the claim to be exempt from coercion in acts of conscience and worship, loses its claim, or comes close to losing its claim to be beyond the competence of the state or the culture. Conclusion. The position of dignitatis humanae is not nearly as simple as people think. It's terse, only 4,600 words. I think some confusions about the document could have been avoided had they included the narrative, which I've only given you a piece of. I've just given you a truncated piece of the narrative that was necessary to see how the two parts fit together. They couldn't do it. In fact, they couldn't agree on it. Okay. And there are problems we face. Not just the problems of not having put the narrative in there. There has been a historic quest of the Roman magisterium to integrate international law and then the Human Rights Project with natural law. I mean, it goes back to Leo XIII, right, to some extent. And let's say the peak of this ambition is probably the 1940s to the 1960s. Certainly the 1948 Declaration of Human Rights that was overseen by a Catholic from Lebanon. The 1949 Basic Law of the Federal Republic of Germany looks like the church is on the same page with polities on this. And then Pacem in Terris, and then Dignitatis itself. The problem as it emerged is that the premise of human dignity in the natural law part of this really did depend, from the church's standpoint, on a human person open to reality as a whole. In late modernity, only scientific materialism promises that human reason is open to reality as a whole. But it succeeds at the cost of erasing all of the other evidences and ranges of experience and being, not just moral evidence, but even the human knower himself, who becomes a kind of useless cultural meme, having no ground or role in nature. And in fact, in late modernity, the specifically human is usually put on the side of convention. That is, culture, human laws, and values which are absent from nature. And if this is the case, then the human rights legislation and its various instruments are only another species of human convention, perhaps in the fashion of international law with the value-added emphasis of morality. The norms, however, would reside in the agreement, not in the nature of things. Now, here is another reason to read Dignitatis backward 50 years later. Part 2, which is part 1 in historical and doctrinal time, is fixed, more or less. Even in the case of a political authority who is baptized and can make a formal assent of faith to the Constitution of the Church, even in that case, he is forbidden by Vatican I to transgress the liberty of the Church or to reassemble the Church as some organization other than what it is. That part is fixed. It has a kind of lucidity and coherence to it, no matter what happens to the Human Rights Project. Part 1, which is actually part 2 in historical and doctrinal time, the natural law argument is far from fixed. And where it once seemed to be more or less settled, it's no longer settled. Today, the Church asks political authority not to recognize the truth of Catholic Christianity, but uphold the anthropological premises in what pertains to the inclination to know, practice, and communicate the truth about God. But this project turns out to be much more difficult than anticipated. It was one thing to ask in the late 19th century political authorities to keep their hands off the Church, so to speak. That turned out to be the easy claim. In fact, most governments in the West don't want to govern or manage the Church. They have other problems in mind. Putin might, and the Chinese, perhaps, but most Western regimes don't want to fiddle with the internal governance of the Church. But it's quite another thing to require temporal authorities to uphold the anthropological premises which govern appeals to religious liberty in the public square. The natural law argument is actually more difficult to make. It was easier, it's an irony, it was easier for Catholicism to get out of political Christendom than to get it into the human rights discourse in the courts of Caesar. And thus we see, even in our own time, that appeals to human rights regarding religion, when made by the Church, more often than not are done in a purely defensive situation. This is not some sort of conversation with a high humanism in which we're all on the same page together, just having certain practical differences about the conclusions. Rather, it's a down and dirty legal and political contest over the right of religion in the public square. So part 1 of Dignitatis Humanae is still a work in process for all practical purposes. Here I've given you a summary of the introduction, because the rest of my paper is what Aquinas would call the virtue of religion, the natural virtue of religion, under the aspect of justice, of giving due to God, how we have to interpret the virtue of religion after Dignitatis Humanae. But that's a different story, and John will have a book with me in it, telling the rest of the story. Thank you.
The preceding program is copyrighted by Emory University.